Hello and welcome to the latest edition of Wright Hassall Real Estate Rundown. My name is Andrew Jones. I'm a partner in the commercial real estate team here at Wright Hassall, and I'm joined today by my colleague Ben McCosker. Hi Ben.
Hi Andrew.
Ben specialises in property disputes, and I've roped Ben in today to talk really about some reforms that the Law Commission is looking at in their 14th programme of law reform, and in particular the Landlord and Tenant Act, or Landlord and Tenant Covenants Act 1995, which from my point of view has been ripe for reform for quite some time. But perhaps Ben, you could just explain a little bit about what the 1995 Act intended to do when it was first brought in, and how it's evolved through perhaps some cases over the last few years, really.
Yeah, absolutely, certainly. So, yeah, the 1995 Act, ironically, was as a result of a prior Law Commission report. And what they were doing was, the problem that they were trying to solve was that generally, in our law at the time, tenants who assigned their leases would still be caught by their obligations for the remainder of the term. So you're a tenant today, you assign the lease, it's got another 20 years to run. 5.5 years' time, your landlord knocks on the door, there's 5.5 years worth of arrears accrued, you can still be sued and there's no defence in limitation. So every reasonable person, property practitioner or otherwise, would accept it's reasonable to say that shouldn't happen. Yep. And so effectively that's what the Law Commission consulted on, reported on, and we then get the 1995 Act, which basically says that from a new tenancy, which is a tenancy granted after the 17th of July 1995, a tenant will be released from their obligations. It also said that to the same extent, a guarantor will be released from the date of assignment, coextensive with the tenant. The Act rendered void any agreement trying to mess with that, essentially. Okay. And it provided a limited exception, which is what we call the Authorised Guarantee Agreement, or the AGA as we would know it, and that's Section 16 of the Act.
And that's where an outgoing tenant will guarantee the incoming tenant. And the idea was that you guarantee the next person or the next company down the line, but that's where it ended. So if there was an assignment, you'd be let off the hook effectively at that point.
Absolutely. The primary purpose was tenant and guarantor should no longer be caught, as a rule of thumb, after assignment.
So we move on and we get into probably the 2000s, and I'm not sure what year it was, but there was a case, I think the first case on it was Good Harvest. What was that about?
So yeah, Good Harvest Partnership LLP versus Centaur Services. It's a 2010 High Court case. And effectively, in an under-lease scenario for 10 years, in those circumstances, the landlord, the tenant and the guarantor all effectively agreed that the guarantor for the original tenant would guarantee the obligations on assignment of the next tenant. And it's the first time that the court had to really grapple with looking at these provisions and deciding what they meant in practice, and in particular the anti-avoidance provision that I mentioned earlier, as in you can't agree otherwise than what we're trying to do here, which is release tenants and guarantors after assignment. And the court said, no, you cannot insist on a guarantor guaranteeing the assignee, the new tenant's obligations. They are effectively released.
And that was then followed by KS Victoria, which I think was a Court of Appeal case. So that affirmed kind of what Good Harvest had said.
It did, affirmed, elaborated to an extent. What the Court of Appeal said in KS, which was a similar, it had to ask and answer the question, okay, in Good Harvest, they stipulated that must happen. What if the parties voluntarily agree that should happen without it being a requirement in the lease that the guarantor does guarantee the incoming tenant's obligations? And
did they deal with that?
They did deal with that, and the court said, no, don't like that either. Right. No, we're going to be very strict here. It produces certain results and say you can't, whether it's of your own volition or pursuant to a requirement, you can't do that except for under Section 16 Argus, the limited exception. That's Argus,
So this now starts to cause a problem in the commercial world, where there's, particularly with intercompany, intracompany transfers and guarantors from parent companies, and we'll come on to that in a second if we may, Ben.
Yeah.
But I think what I find really interesting is we move on from KS Victoria in
2011
to 2016.
Yeah.
And the EMI Group case, which I think is even more draconian. Which perhaps you'd explain that one.
Yeah, absolutely. That was more draconian, effectively. So what happened there was the tenant assigned the lease, the relevant lease, to its guarantor.
Yep. Seems reasonable.
Seems reasonable. They're the
Guarantor
ones with the
was already-
covenant strength, right? You know,
Yeah,
commercially,
guarantor was already liable.
absolutely. All parties, ostensibly, particularly where all parties are ostensibly happy with it. What's the problem with that? Well, the problem with that, the court said, was that the policy behind the act was to effectively release the tenant upon assignment and coextensively any guarantor that existed at the time. So, if the tenant assigns their lease to the guarantor, there's been no coextensive release of the guarantor. It's effectively shouldering them with the same liability as they had before the assignment, and that was the problem.
And you do wonder whether in the EMI they structured that deal because of Good Harvest and KS Victoria. You do
Quite.
wonder that.
Yeah, I mean, there was a question mark about whether or not that was viable. So I'm not sure how conscientious they were of it. But as you say,
Yeah.
you just think, well, actually, upon assignment, tenants released, guarantors released.
Yeah.
But then the guarantor's obligations are, if you like, pursuant to the lease now.
Yeah.
But didn't like it.
So in the real world, as it were,
Yeah.
this then gives us some commercial issues. A real live example, I think, is where there's two subsidiary companies and the parent company, subsidiary one, has entered into a lease, parent company has acted as guarantor. For commercial reasons, the subsidiary now wants to transfer it to its sister company, and that company has not got a great covenant strength, and the landlord says, well, we'll just take the guarantor from the first lease.
Yes.
The same parent company just enters into guarantor.
Yeah.
And my understanding, Ben, is that would not be valid.
Outside of Section 16 ARGAs and GARGAs,
Okay.
you're quite right.
So just explain. Let's take a step back then. Just explain how it would work with an ARGA and a Gaga.
Lady Gaga. Lady Gaga, yeah. I'm not sure she was popular in the noughties. Was she? Maybe that is when she came onto the scene. But so basically how that works is, provided you've got an agreement that satisfies, I won't go all through all the requirements, it's a bit too technical, Section 16, then a tenant can guarantee its incoming tenant's obligations. So in that way you keep them on the hook under such a guarantee.
So in my example, subsidiary one would enter into an ARGA to guarantee subsidiary two.
Yes.
So what's then the status of the parent guarantor?
Yeah, so basically, the court doesn't seem to have a problem with that, because effectively the release has happened, and what the guarantor is then doing is guaranteeing the original tenant's obligations under the authorised guarantee agreement, not the tenant's.
Hence the expression Gaga.
Gaga.
Because it's a guarantee of
the
an authorised guarantee agreement.
Yeah, and it does feel overly cumbersome around the houses. I think the commercial realities of it, why people think this is so absurd, is because where three parties get together and think, we're okay with this, they think, so why can't we do it? But the court has said, look, the test is not your subjective intention. The test is the objective effect of your agreement. And if the objective effect of your agreement is to keep guarantor and tenant on the hook for liability ongoing without the ARGA or the GARGA, then it doesn't matter what you want to do, that's unenforceable.
Because of the strict anti-avoidance provision.
Anti-avoidance provision, Section 25. Absolutely.
Yeah, so whatever the parties, grown-up, commercial, corporate clients and parties think, the court says, I'm sorry, you're not grown up enough to make your own decisions, and the law overrides that.
Yeah, outside of an ARGA. But part of the reason for that is, of course, that the court has a certain constitutional function, has to interpret and apply legislation, the will of Parliament. So in a sense, in one sense, it does produce commercially certain results, because parties know we cannot do this outside of the limited exception of the ARGA and the GARGA. So they do know that, and they're fully aware. And I think the 1995 Act is a classic example of the law of unintended consequences, which is, the law says, quite rightly, we shouldn't by default keep a tenant on the hook in perpetuity for a liability that really is no longer theirs. But in doing so, it's created another rule which says, and even if you want to, you can't choose to, outside of this situation here.
So from an investor point of view, I can see problems.
Yeah.
Because it's all about covenant strength, and that will have an effect on capital value. So if a landlord is forced to accept a weaker covenant and not take on that guarantor 1, 2, 3 assignments down the line, then that could potentially water down their capital value, their investment value. Even worse, they've inadvertently done this. So there has been an assignment between two companies, and the same guarantor has directly, principally guaranteed the assignee. Then arguably, in fact, pretty certainly, that guarantee is no longer valid, and that could have a detrimental effect on the capital value of that investment, because the covenant strength is now not what they think it is.
Absolutely, hugely so. But as with anything in our game, prevention is better than cure. And there is a later EMI case, a High Court case of 2020, EMI Group Limited and Prudential Assurance Company Limited, where a successful AGA and GAGA was created. And in particular, that case said, if the landlord, under the lease with the tenant, stipulates as a condition for the assignment that an AGA will be required and is a reasonable requirement, then in a sense, there's no argument as to that, whether that's a reasonable condition to impose for the assignment. And if that's so, then you can require, as part of the original lease, the guarantor to guarantee the obligations of an ensuing AGA under the assignment. And that worked.
Yes, that works. But the problem is, if there is another assignment, then the original guarantor presumably would be let off because that GAGA can't keep continuing. They can't enter into another GAGA, as I understand it, Ben.
Yes, and in that respect, it is all a bit gaga. But and I think the most ready. It's good that the Law Commission are looking at this, because the most ready solution, to my mind, it seems to me, without ousting the original purpose of the 1995 Act. Yes, everyone agrees you shouldn't keep a tenant and a guarantor on the hook in perpetuity without their choice. Keep that. But surely it's remedied by a saving provision in relation to guarantors, which states, unless the guarantor is otherwise amenable or willing and agreeable to successive guarantees on assignment. Because where you've got one that's willing, what's the issue?
So do you think that's where the Law Commission will move to, is some kind of contracting out provision or something like that, or is it way too early to say?
Way too early to say. I mean, we were discussing just before this podcast was recorded that actually, from the time they originally consulted about the 1995 Act to its enactment was about 8 years. So if we're looking at the similar trajectory, we could be talking, this is all conjecture, we're just guessing. To my mind, it would be the most ready solution. I don't think there should be a carve out for tenants in that regard. I don't see the need, because like you said, in the commercial scenario, the covenant strength is coming from the guarantor in any event. So just give them the choice. Give them the choice. Very easy saving provision that says, a guarantor's liability, coextensive liability, will be released except where the guarantor agrees otherwise, and surely that solves the problem.
Yeah, no, thanks, Ben. I think, in my world, I have come across this in practice, particularly where you're having a company reorganisation and there wants to be an assignment. Where I've come across it mostly is an assignment to the guarantor, actually, and it's pretty clear that that first EMI case followed KS Victoria and said is void, and then you end up trying to sort of come up with other solutions which aren't brilliant from a tax point of view, and tenants end up paying more tax and inadvertently, stamp duty, land tax in particular, I'm thinking. So it's messy, and frankly, I don't think commercial clients do not understand if they have got an agreement with themselves effectively, often because they're in control of the group. Why can't I do this?
Absolutely, and I think that is just about managing their expectations, isn't it? And just explaining very simply, look, despite the fact that you may agree this, the law says you can't enforce it in certain situations. And at the end of the day, the property practitioner should not really be required to be seeking ways and means outside of the AGA and the GAGA to avoid it, hence anti-avoidance provision. That's the point.
Yeah, absolutely. But it's not commercially viable.
It's not commercially viable.
Hence the fact that the Law Commission's looking at it. So look, let's watch this space with, I was going to say trepidation, but maybe expectation is the better word.
Absolutely.
See if this can be moved forward.
Yes, and hope they're quicker this time round as well.
Thanks for your input, Ben. Cheers.
Thanks, Andrew. Cheers.